Anyway, so I see a lot of turnout. Thank you for this. I'm very keen to see you all here. I will now distribute something that I nicked from Mark when I last did some workshops with him. These are the pipe cleaners. They have different various colors, and they make it. Just take one each, anyone you like, the color you like. You can use it to ease off the stress of this super case study that I'm going to perform here. Mark says that it allows you to keep off the phone, so you can have some thing to do with your hands. Pick a color, any color. You're welcome. There you go. Oh, you have some? Okay, here. Okay, and then taking this opportunity, I will just tell you. My name is Jacek Pakula, and I'm an attorney at law in the law firm of Atradius. We have one law firm, Atradius, in Warsaw, and as a part of Atradius Group, Atradius Collection, we are the lawyers that go to court if the debtor does not pay, and if we cannot go for amicable collections. So if there are two, okay, no problem. If we have enough, you guys, there you go. Yep. Yep. You're welcome. Blue. Anyone here that does? Oh, okay. Yeah. Okay. One for you as well. I have some more. I'm prepared. Mateusz will hand out the pipe cleaners to everyone who doesn't have one. You have your case studies distributed. I put them face down, so you're not distracted by them at this moment. The whole thing here is about that I will give a lecture to you, but firstly, these pipe cleaners were the cunning plan for me to divide you into groups. So these are the groups that you're into. So your color is your group. So if you like to sit together, you can do that, because I thought maybe if I divide you into groups before the case study, you will be more engaged, and you'll be more prone to listen, because you're going to be the team spirit. So if you like, you can switch places, but you can then switch places after the lecture, so the groups will be divided this way. When I met Mark, he asked me to hold this presentation because he said people are not always aware that with regard to the debts that we have, there are some extra benefits, extra compensations that we can have whenever there is debt in our company. Let's say you sell pipes and you sell them all over the world, including European Union. And there we have this derivative on late payment. And the answer about the cat will be at the last slide, so don't worry. Let me just see if it does work. It does work. Okay, so let's do some basics. Very, very long and boring name, don't have to remember it. We'll just call it the Late Payment Directive. Someone knows what the directive is? Yes? What's the difference between the directive and the regulation?
The directive must be transposed into local, national, regional law before it becomes effective, and the regulation is applicable.
This is a great answer. This was the great answer. So the regulation is just the law. The EU sets the regulation, and it's in force in all of EU countries. The directive, however, is just like a directive. It's that these are the directions that the national law should go. And what does it mean? It is differently applied in all EU countries. So you'll see these differences, and this may impact your collection process. Okay, so we have a few definitions here. I wonder if I didn't. You should be okay. Okay, I thought I have some one slide with the contents. Okay, so we have few. I'm not here to teach you definitions or even dive into the law, but I just wanted to tell you that this was introduced because imagine there are some big companies like maybe, let's say, big supermarkets that they can force people, if they have buyers, they don't pay them very soon. They pay them rather later than sooner, and it may impact the small business. So the EU decided, let's have this directive, let's set some good practices and laws, for that matter, so the countries will be, so the small suppliers will be protected somehow. There are some definitions. Okay, few definitions under the payment directive. There's Article 6 that we're going to focus on. It says about the compensation. This is the extra money that you can get on top of your debt. There's a case of Court of European Union, Court of Justice, and there I mentioned something about interest rates. It's also very, very helpful, and very it can be very profitable, as you will see in the case study, and then in the end will be the case study that you will perform. All right. So again, this is you can download it from the website. It's in every EU language. The directive is not long, but again, as you said, it's not the law yet. It's just what the countries have to do in order to be compliant. But it's basically, as you say, the directive is this act that many countries have to adopt their own laws to be compliant with the directive. Not regulation. Okay. So there are a couple of definitions there under. The late payment. Payment not made within the contractual or statutory period of payment, and where the conditions laid down for article something and something are satisfied. And these two conditions are important. They will be repeated throughout the directive. The creditor has fulfilled contractual and legal obligations, so we actually delivered the goods and they're there, or we perform the services. And the second, the creditor has not received the amount due on time, and so the debt is mature. So if the invoice says it will be payable in 300 days, well, before maturity, it's not a late payment yet. Unless the debtor is not responsible for the delay. And yeah, this is self-explanatory. So this is one of the definitions, late payment. Another definition is commercial transactions. So basically, these are the transactions. It's a B2B transaction. This is what we do in Atradius collections. We mainly have these types of situations where it's unpaid invoices for goods or services within the business world. So it doesn't pretend to consumer relations. Undertaking, this is the organization or any public authority acting in course of independent economic or professional activity. So these entities, undertakings, these are the companies basically. But also, as you see, public authorities are within that region. So you could also demand these compensations, these interests, these types of compensations from public authority if they're a part of transaction, if there's a transaction pertaining to their kind of economical activity, not their state activity as such. And the amount due, well, this is the principal sum which should have been paid with a contractual or statutory period of payment, including taxes, duties, levies, and so on and so on. So the final amount on the invoice basically would be that amount. This is statutory interest for late payment. It means simple interest for the late payment at a rate at which is equal to the sum of the reference rate in the last 8 percentage points. Well, this is what I will not delve into that because basically every country has set the bar differently. For example, where I practice in Poland, we have interest for late payment and interest for late payment in commercial transactions. There are two different interest rates. We also, for some strange reason, we divide interest in Poland between interest paid to health authority or something that is not health authority. I will show you later the very good website you can click on. It's an EU website. It's basically you can calculate every interest for every EU country. So if you have a debt of, that will be a part of your case study actually. If you have a debt of say €1,000 and it's been due 2 years ago, you can just click on the website and just go there and just make a quick calculation what is the due interest under this directive. So if you click for Poland, it would not be a normal civil code interest rate, it would be just this one, which is higher. And it's important because if you go under your local regulations, if you, for example, you're used to, let's say, German interest rate or a French interest rate, it's usually lower than this one. So if you have a transaction that is fulfill all these requirements, you can grab the higher interest rate, and you can have more return from your unpaid debt. Let me just switch to some. Okay. So we have interest and we have compensation. Two different things. The European Parliament, by such, they figured out that, okay, interest rate is one thing, but you will also you will have some costs of your collection. So some collection costs, be it you employ someone that does it internally, or you outsource your collection activities. There is always a small fraction of cost, and they decided it's going to be 40 euros. But they set it as a minimum bar. So they said, okay, every country have to introduce the legislation that says that you will have to pay extra 40 euros for unpaid debt. Okay. So, but some countries, as you observed before, they introduced different regulations. They said, okay, but maybe for higher debts, we would like to have more compensation. And they made some statutory, just because it's a minimum sum. To be honest, I'm not fluent in all European languages. I tried to research everything in English and in German I could find. And everywhere I see, it's usually 40 euros, which is strange for me because Poland has 3 thresholds. I will show it to you how they work. Well, basically, there is a small threshold. First one, 40 euros. When the debt is larger than, I think, 1,200 euros, something like that in Polish currency, in a very strange, difficult to calculate exchange rate, it is 70 euros. And when the debt is higher than 11, I think, 1,000 euros, it is 100 euros for debt. In your height probably goes a question, what is a debt? If we have 15 invoices, is it one debt or is it many debts? If we have one invoice but 40 deliveries under this one invoice, is it one debt or is it multiple? This is the main question that will be addressed on the next slide when we go to this ruling of Court of Justice of the European Union. So that the member states ensure that fixed sum refer to paragraph payable without a necessity or reminder as a compensation for credit on costs. And the third part of this Article 6 is also important because the creditor shall, in addition to the fixed sum, so the 40 euros we have above, be entitled to obtain reasonable compensation from the debtor for any recovery costs exceeding that fixed sum and incurred due to the debtor's late payment. And also, they wrote in the directive, this could include expenses incurred inter alia this is fancy Latin for among others, in instructing a lawyer or employing a debt collection agency. So they even thought about debt collections agency in the directive itself. What it means that, for example, if you have 1,000 euro debt and you were able to collect half of it through the collection agency and they charge you, say, 10%, so they charge you 50 euros for that. So you can claim 50 euros, not 40, because this is where your costs. You have a invoice from the collection agency. Thank you, here's your 450 euros that we collected because we collected our 50 euro fee, and you can include that. That invoice from the collection agency for 50 euros in your court claim when you try to claim the 500 euros that are still not paid, because these were your costs, and they exceed 40 euros. But you have papers to prove them. All right. So this is the very, very small print about this judgment. I will try to move quickly through the judgment as it goes. So there were 2 questions, and the case is, by the way, Polish. So there was a Polish entity that had some unpaid invoices for some deliveries, and they went to Polish court, and they also claimed 40 euros per each delivery. So I'm assuming, because it doesn't say exactly in the recitals of the court, but I assume they had an invoice that was split into deliveries, and there were many of them. So I don't even know if the compensations exceeded the actual debt, and the Polish court asked the European Court of Justice of the European Union, they asked, well, how should we calculate this 40 euro? Would it be just for this invoice? Would it be for the whole contract that they had? So there were like 3 invoices under the contract. Would it cover only the whole contract, so 140 euro per whole contract? Or would it pertain to every delivery of every, under every invoice? So in short, they came to a conclusion that, well, every delivery should be a separate debt. So not only every invoice, which is usually the case, and I probably don't know if you have such calculations with your debtors that you divide your invoices into separate deliveries, but it happens. But it's usually one invoice, one delivery. But let's say it's one framework contract, and the invoices are vast. For example, I have one client, and they offered fuel cards. So you can imagine they have like 30 trucks running. They have 30 fuel cards, and I think they invoice them every Saturday or something like that. So when there's a large fleet of cars, these invoices come every Saturday. So there's like 4 a month, and sometimes they're large with the large fleets. So then we could argue for a client before the court that, well, each of these invoices is worth extra 40 euros without even coming into the cost of real collections. And this was a groundbreaking ruling from the court. And this had large repercussions, because before that, I remember when we tried that with the courts were very, in Poland at least, they were very reluctant to give these small amounts for each delivery or each invoice, because they sometimes exceeded the main principal debt. And they said it's unconstitutional, it shouldn't be read like that. But from this case on, I never had a court who rejected that type of calculations. So whenever we have a case with multiple invoices, we develop a special tool. Okay, very fancy. We develop a special Excel sheet to put in all the invoices that calculates these small compensations, and we add them to the grant. The only thing that I don't know how the different countries are operating on this matter, but when we go to court in Poland, we pay a certain amount of court fee, and it's dependent on the case matter value. So when we have case matter value of 10,000 euro, we pay 5% of that is a court fee. And when we add this extra compensation, let's say it would amount to 2,000 euro, because we have a lot of small invoices, we would pay 5% from this 12,000. Some courts see it like that. Some courts see it's an extra thing. You don't add it to the case matter value. You just pay 5% on your 10,000 euro debt. So, and sometimes we argue with the courts when the differences are large that we shouldn't pay this extra court fee. But this is a very national thing. I don't know if it looks very similar in other countries. So since that, we already knew we have a very high interest before, but then we now know after this is 21 okay, so it came out 3 years ago. Now we know that we can go to court with all these small compensations. So what it gives us. Okay, so let's jump back to interest rates. All right. So this is a very handy QR code I prepared for you. If you scan it, there's also the link is down below. There is this quick life hack that I told you about before. You can go to EU website, input any debt from any country. You just have to say if it's against a public entity or a private entity. You just have to. There are like a choice of 2 boxes. Either both companies are in EU or not, and then you can calculate, because different countries have different ways of basically calculating these interest on late payment. Sometimes they put in the civil code, like the Germans, they put it in the civil code. It's fast. and if they want to change, and in the civil code it says it's 8 percentage points plus some European bank exchange rate. Then you have to see what's the European bank exchange rate, and they multiply. In Poland, for example, they publish the percentage rate, and the National Statistical Office publishes it every time. Usually every time the interest rate change in the country, they change it. But I've seen many different ways. In Belgium, for example, they also publish in some national gazette or something like that for statistics and economics. But this tool doesn't allows you not to click on every website, every country, and every language, but you have it in one place. It will be very helpful in your case study. Okay, so we have contractual interest rates. Basically, if you don't want these interest rates, which are considerably high, but you want higher, you can write into your contract what type of interest, what percentage of interest rate would you like to collect. And I have clients, for example, that operate Europe-wide, and they just want one interest rate throughout the whole Europe. So they just entered in the contract, bless you, that this one interest rate. But the problem is that if these interest rates are too high, they can be deemed by a court as unfair or as usurious. I've seen many scams. I worked for a company that was doing these micro loans, and they came up to me when it was way before my collection days. They came up to me and they said, "Okay, we have a super product. You go to your local agency, and then you can borrow some money. Let's say very small amount of money, 100 zloty, and you will pay us after a week 120 zloty." Well, that doesn't seem like a very hurtful deal. But then you think about it, 20% weekly, it's a monstrous interest. So sometimes a company, let's say, it's like a 1% a day or something like that. They just make it smaller by shortening the period. And I was looking for a definition of maximum interest rate, because if something is maximum, it means it's still legal. Over maximum, oh, it's not allowed. So in Poland, we do have that. It says that the normal is the maximum. Beyond that, you just do too much. And because I was kind of shaping the case study for today for two cases for Germany and for Poland, I was trying to look for maximum interest rate in Germany. And I couldn't find the law that says what is the maximum interest rate. They only said that something that is 12% above the legal standard is too much. So I'm assuming 11 for Germany, but I don't know if there are any German lawyers here or German practitioners that could confirm that. But this is what I gathered from reading multiple articles about that. So if you really want to squeeze the debtors in the end, you can try to search the proper jurisdiction and search the maximum interest rate there is in the country that you're trading or the country that the law of the contract is under. So, and as I'm saying, in Poland, this is 22.5%. Germany, I would say 23.37 as a safe number, because 12 is there is a court ruling in Germany that says 12 is over the normal, is too much. Okay, so how to draft your contract to get the best possible interest rate? The contract or your terms and conditions? Well, what you can do is basically, the law of choice is the place where is the highest interest. But of course, maybe the highest interest is, I don't know, in Iran or maybe in Kenya or somewhere that we don't want our law to be there. So I would recommend, if you have multiple headquarters or multiple offices around, let's say Europe, because we're still under the EU directive, you can try to see, and I think they have provided, okay. So this is also from the website I told you about. I downloaded it 2 days ago, I think. Oh no, last Friday. So I think they haven't changed. The brackets there is, until the end of 2024, but these exchange rates change. You can see these small dots here that didn't download this part, but they say it's to be confirmed. So the EU is not also not sure with these countries. But you can see the Czechia, Hungary, Poland, other than public sectors, because the health sector is other public sectors and normal sectors as well. This count under because the public sector of health is excluded. They have small interest. And Romania, they have relatively highest interest rates under the late payment directive. They may have lower normal rates in the business or civil transactions, but this is what they have here. And these are not the maximal interest rates. So you will have to refer to your lawyer in the country of origin. I can only tell you about Poland, a little bit about Germany, the research. But you can either say nothing in your contract, and if it's a commercial contract that is under these definitions that we went through, you will, and if you choose the law of one of these countries here, you will have such an interest rate if you say nothing. If you say a fixed amount, please consult with your lawyer to see if they are not too high with regards of the standard of the country that is in question. Maybe they're too high, they're over maximal. You can say also set lower ones. I have a client who set 5% across the European Union because it was more convenient for them. And we can do nothing about it. We talk to them and maybe try to do something to change that because you're losing money, basically. But it was their decision, and basically their relation with the client was in such way constructed. So, this is a case study. I would like you now to maybe shuffle and go to the groups that you're assigned by the color of your pipe cleaner, if you would like to do that, and uncover your magical case studies. I try to do them, and I'll be here to help. Mateusz is also here to help. It took me about 7 minutes to do it, so it shouldn't take you longer. Is the question? Or no? That's the group, the yellow group. Who wants to be a leader of yellow group? Leader? So here, yellow submarines. This is your group. Pink? Pink Panthers. Here's your group.
Pink guys, okay. Pink is that. There's actually more pink here, I would say.
Pink Panthers here. What's the color here? Blue. You are. Of course, you are. Blue Lagoons. Black? Yep. Black ties.
So who's the next person?
Boston Red Sox.
Oh,
There you go. And Green Goblins. There you go.
Hi, nice to meet you. No.
Of course, we have some spare. Does anyone else need the papers? Of course, please be some kind. Thank you very much. Once more.
Thank you.
It's just a one pager, yeah. Yeah, the question is underlined. It's basically, where would you go to court and why? Assuming you want to fully squeeze the debtor. Yeah. A Polish attorney. So, this is. Yeah. Okay, let's assume it's Polish. We may assume that. Yeah, yeah. You can do that to justify the Polish-German choice of law, because what happens here? No, actually, sorry. You're a German company. Polish diplomat. This is the other question, because you also put the part of the questions here on the in front of you. This is how the terms and conditions of the company that is selling the lasagna look like. So let's say some Polish company clicked on the German company website. They bought these lasagnas. They got these invoices and inventories, and then deliveries. And this is their choice of law. EYC is your company, your client, and the buyer is the customer is the company that is issued to. So they have where to go to court and what law shall apply. And I'm here to help you because I realize not everybody's a lawyer. I can go, but this is basically. Do you think this under these? Yeah. And if you don't see this from the far behind, I can read it to you if you like. There are also some traps in the case study, as I'm very cunning. As my friend who's not a lawyer said, I'm a cunning lawyer. Why are you cunning? Because I'm not a lawyer. Okay, try to use the zoom option.
Yeah, so nobody has the extra in head. Hey, you're the boss of the group, aren't you? You got the ball, I saw that. So.
No, I was trying to calculate
Oh,
the
yes.
different rates for employees and to see how
Yes.
the rates based on the value of the numbers and the due date, because then the rest can be more interesting with the smaller invoices, and then I don't know, I was just starting to check which one would be the most interesting, and I think
Any questions I can help with? The square here, well, the QR code goes to the website. I told you that calculates the interest rates.
It's everything.
Everything.
Are you a lawyer by chance?
Unfortunately, I am.
So,
It's,
what you solve for us?
but I'm just the end product. You need to solve for yourself. Before you go to a lawyer, you need to know which one to pick from which country. Oh, you're on the website, right?
the entry date is today.
Yeah, let's assume. Yeah, let's assume you calculate the final date of payment is today. So you calculate interest for today. Good question.
I have a question.
Yes.
But it's 1 year old.
Well, we have to do this until 23. We assume that the payment date is today.
I would go to Germany anyway.
So because we have the
But it's
So
you never know how it will change, right?
it says the jurisdiction is the place of jurisdiction. So where you go to court. Also, in international context, for all disputes arising from the business relationship, from this business relationship, also after its termination, is Düsseldorf, Federal Republic of Germany. This place of jurisdiction is exclusive for all actions against our customer. For actions by our customer against the other debtor, it applies optionally alongside other statutory or agreed upon places of jurisdiction, elective places of jurisdiction. So, in layman terms, it basically, this company is kind of cheeky. If you want to sue them, you go to Germany, Düsseldorf, maybe for these expensive German lawyers. But as you see on the case study, they're not as expensive. I made it equally expensive as Polish lawyers. But then if they sue their customer, they can choose a court they will go to. Okay, so you can go to Polish court, you can go to German court. But this jurisdiction issue is only a half of the story, because we then go here to this choice of law. There we go. This is my cunning way of bringing your attention to these clauses that always in the contracts are on the last page and nobody pays attention to them, but I think as a lawyer they're important. So we have, what law should we choose here? Polish or German? So what interest rates in our mind as well? So the laws of Federal Republic of Germany shall apply, and UN law on the sales of goods, basically you should say here, it shall not apply. If anybody knows UN Convention on Sales of Goods, they only know to exclude it in every contract. This is whenever you see it, it's always excluded. So, but there's a B here. So, your client can, before or upon initiation of a court proceeding against the customer in his home country, so if he goes to court in the country of the customer, via notification in text form or on the statement of claim, choose a foreign substantive law which applies at the corresponding statutory or agreed upon place of jurisdiction of the customer. So basically what they're saying here is you can apply German law. But if you go to a different court, because you have this other choice of court clause, and you may go to court, in this case in Poland, then you may apply Polish law only if you notify them properly and if you will be in the court of the law that is for. So you cannot choose French law for Polish court. You can choose German law for Polish court if you don't choose to change it. So it's very cheeky from, you know, you can see the market power of your customer here. He's the powerful entity. People want to trade with him, so they enter into these terms and conditions, and whenever they don't pay, they can expect a lawsuit in Germany or in Poland, for that matter, under a German Polish law. So this also shows how you can modify your terms and conditions in your contract to be powerful against your debtors and to give you more options in the process. Because sometimes, as you see from the case study, you will have more compensation, more interest rates in one country than another. And then this may make up your decision where you go to court. Maybe the court costs are lower in one country than another. Basically, all the companies I've worked with, they started with a jurisdiction clause and law clause in their country because they feel safe there, it's okay for them, it's a very good bubble for them. So we established that you can go to both courts and you can choose both laws. But now, the rest of the task is make some calculations. What is more profitable for you? Yeah, so you want to get as most of your client is possibly legal. What is legal? You get for the most legal. This is a small decoy. Everything is done in euros here. There are some traps. I told you. The exchange rate to Polish zloty is not. It will not be needed at any point.
It's 50-50 to guess.
There should be one important question to ask. I haven't got the question yet. So I will answer it myself. No, there is nothing about interest rate in the contract nor in the terms and conditions. They didn't enter any interest rate there. That? Okay, so it still was not a question. It was just reaffirmation. So no one wrote nothing in the contract about that. That gives you options. Because we're not having two clauses on the jurisdiction law, we could have these doubts. Was the delivery, was the contract signed, did they transfer X large, so did they give for example, logistics center, but it doesn't matter because, you know, I will remind it. But now we have to get choose for the law. Flexible, law flexible I don't know how to say it.
But already there are just compensation. One last. Well, I just did for the two first depositions just to see if it's I think the reason is
all your compensations. You will have some amount.
So the interest is written here.
because in
In Germany, it's 12.37%. From this more than Germany, and this you get more on this one. So you just get more of
No, oh, that would be great, right? That would be amazing.
We have an answer.
It was a good question here from the Blue Lagoons. They ask if they can add the compensation in the case of, let's say, Polish invoice number 1, which is so high, so the compensation is 100 euros. Can they also apply the interest rate to the aggregate sum? Oh, it would be rich. Ha, no. We apply the interest rate to the invoice itself, plus we get the compensation, right? So this is, and then, yep. You won already. The yellow submarines are there. It's clear. Go for Germany. So what is the method? Uh-huh. And which interest rate did you apply? Ah, you fell into my little trap. I said that there is nothing said in the contract about interest rate. Which means that no, for the max interest rate you can go when you have it in your contract. Yeah, the EU, because if nothing says so, you can just first you look, okay, which law am I under? Let's say German, and you go to the square QR code and see how they work. Because if you had a contract that says maximal interest rate will apply to Germany, or maximal Polish interest, or any maximal rate of the country of chosen law shall apply, or 22 point something percent will apply, then you could use it. But if you don't have indication of the higher interest than the law says, you have to go to the current legal. So the result is probably Poland, but not to spoil anything before. No, you will not. So you will not win then. No, but I'm just joking. The result is that you also see if you would apply these rates for Germany, for Poland, just do it with one. Just see, because then the calculator of the EU will show you that the different rates apply on different dates. They're changing in time. So it's not easy to calculate just through without these calculators. So that's how you apply a principle. It was not specified. There was a question here, and we assumed it today. So we calculate maturity for the 10th of 7th of October. No, because this is just a case study, because you don't know where you're going to get so whenever I go to court, I make calculations and I provide to the court the calculation. And actually, I don't even do that in my country, because I just say, I want this amount of money plus statutory interest of the European Union directive. And the court shall calculate it for me on the date of the verdict. Yes, technically, going into legal stuff, I could calculate it by myself, add it to the case material value, make my case higher, and collect interest on that, on the top of that. Which is a rare thing. Clients don't like to do that because it makes the court fee higher. So. And it's also a pain in the ass for us to calculate and for the court to apply, and for the enforcement bailiff to apply. And so we don't do that. But if I had only one big case, I would argue with the client to do that. And I had one big case with a large promissory note, and the client was really angry at the contractor, and I tell him, well, we can do that. So it's going to be with your large amount. And they agree they pay a little bigger fee and they want. So, but I do it really when I have a customer that has maybe 10, 15 cases a month from me. No, because also the court does not say how much. Because then the bailiff has to check. The bailiff goes for the interest. I only check it when the debtor comes to me during a court proceeding and says, geez. Say, okay, so you came to me now, so let's calculate for now. So now I do the calculation myself. See, interest is this, court cost is that. If we go to the judge and say we don't want a verdict, it's going to be lower, so we can deduct it from your payment, and I will give you 10 months to pay. Then I calculate it. And the court applies the example. Yes. Yes. I have the solution somewhere. It looks to me like you may have applied the maximum interest. Let's just try that for you. So it says there's nothing. It means that we cannot go for maximum interest
The question is which court to go or how much you should
terms and conditions.
which court to go
Together, 5,000
It was that because of same
compensation for 100.
they are trying to create I also that actually I was
If you would not use the language, but just one of these figures applied directly, you can use just so yeah, so you will have this is also a
I think for us, because I once you approve it or once you we will put it in the mail board and then there is no like a dashboard to see. So, I mean, maybe there is a way to spend yeah, but I think that they received that from so that could be like there. And the problem is because I thought that it could be done so fine this thing of implementing something but for what I understand actually this transaction
This is theoretical.
Repeat of the work always done because there is screen before and all these things are one month after and you want to look at that enough.
There is a relatively high percentage of people that are like go on process, yet at the end they are not. We don't sign them. So that was one like now set up that we are like requesting approval from the requesting then we request approvals and basically then it doesn't materialize. So we kind of take it and maybe wasting time. We agreed that she also will
But also the invoice electronic charge,
Just as you have been.
So do you assume that there is a screen now? I think that it's there.
Anyway, no, if that about it will provide some documents.
it's not the fly, it's not
like for example, tax ID they need to verify the data. And then it counts, but just some information exists or not exists. It doesn't tell you, like, this is actually accurate. So basically, doing that check is useless, just to see if
First one, submit something.
it's like really difficult because they just want to get information. Sure, sometimes it's like yes,
Okay.
It's something where you find more
This comes from my assumption.
which country a bit like in UK it is
So, and this comes from my assumption of German law that they say this is the degree 12.37, and the court generally said 12% is too much. So if 12 is too much, maybe 11 is okay. So when I applied this rate, but it's well, you can apply it for the case study, but before German court never this is the trap. The proper answer is this square there, because I think the maximum countries, they look very promising, and even German looks bigger, but there's no mention on the interest in the contract. So you have to apply whatever is legal in the country, and the legal would be the square calculation there. Okay. Any questions, or can I maybe do a short recap? Yeah, some questions? My calculations are a bit different. This is my from Poland. This is my Oh, this is it. Yeah, sorry. I added this to yours. Oh, exactly, yes. So we have 200, but I also, this comes from the court case. You've been charged 40 euros on every delivery, not only on every invoice. So in both cases, you would plus you need to use it. So.
I always need to call.
Okay. 1 more minute. Okay. So, which team had the best result?
Sorry.
Yes, everybody wins. No, I seen the result here. It was off by 80 euros, but basically it was there on the spot almost. Here we had a little trap of the sorry for being such a devious lawyer. I gave you this maximal interest, but it shows that maybe you can think about interest in a different way when you be structuring your contract on your TNC, because there are some treasures there, but you need to put them in a contract. So these ones I wrote would not apply because they were not stipulated in the contract or in the TNC. But they actually gave you some options to check, and after my calculations told me that if I would apply Polish law with Polish these funny system of gradually rising compensations, I would have 130, I think, euro compensation in this. And I'm not saying only German, because I think it's the majority of the countries on the list I showed you, they have 40 euros. Their lawmakers just copied directly to the law, and that's what they did. And it would amount to 280 euros of compensation. And for the interest rate, if you went diligently through the link I sent you, so if you didn't fall the trap of maximum interest, I have interest rate for Germany. My result is 4,127.9 something euros, 97 I think. And for Poland is 5,614.57 euros. So if you add the compensation and add the interest rates, normal ones, these are on the European Union side. These are not unfair. These are not maximum. So you could claim 4,400 euros something in Germany. You can claim 6,000 euros more over the top of the debt, of course, extra in Poland, plus the costs. And there are a few surprises here. So I'm sure almost every legal system in the EU has the clause that says if you win, your opponent pays back the costs, legal costs, at least to some extent, the minimal cost. That's what, for example, that's what our law firm is charging, the minimum cost of the legal service, and the court are granting that to the client. When we go to bailiff, we collect this as well on top of interest, on top of the debt, and all of the compensations. So, in theory, when everything goes well, read that. Should we finish? 5 minutes? Oh, 5 minutes, come on. We have time for questions now. Okay, in theory, when we have like a deep pocket defendant or a wealthy defendant, we'll be able, the bailiff would find a nice Ferrari or a house. Then we could not only get our principal debt back, we could reimburse our court costs, our lawyer's costs, we could get compensation, and we could get this really good interest, especially what I told you, if you, for example, if you're trading in a foreign currency, not euro currency, if you're trading in a Serbian dinars, are there dinars in Serbia, currency? My Serbian friend? Dinars, no, you know? Dinars, am I right? Yeah. So your interest rate in your country are high, but if you apply euro invoices and apply your rates from your country, then you can have like amazingly good results in terms of turnout, because you have a high percentage. Like Poland, we have zloty currency is probably not as strong as euro, so our percentage rates are higher. Like Hungary, like Romania, we don't have euro countries, so that's why these. Let me show you. That's why these numbers are higher in these countries that don't have, although we have Romania, Poland, Hungary, and Czechia. Well, there you go, non-euro countries. But you can trade in euro in these countries, of course you can, and you can have these large interest rates on euro invoices. So that's the, and you can shape this contract, this contractual relationship by this flexible clause that I show you. This is a one-to-one example from my client's TNC. This is how they shape. They're a German client, and they have an option to go anywhere they want. Not anywhere they want. Anywhere the client is. So if they see, well, I have a better jurisdiction, I'd rather go there, have a higher interest, they can switch. Client can't switch. They can only sue them in Germany. And I had this. One client, they came to my client for a deposit. They wanted to sue him in Poland because he's sued them in Poland for cash. And we won the case because we say, the jurisdiction is optional, but only one way. Yes?
3 questions or 5?
3 or 5 questions.
What
I will just give you the microphone forever.
From your experience, what's the average length of time of a trial in Poland, and what's the one in Germany?
I don't have experience in Germany. I do have experience in Poland. I have extreme cases being done within 2 weeks. And there's a simple case of invoices. I have an order for payment. Order for payment. These are extremes. Normally it's about 2-3 months for order for payment. Yes, order for payment. Then they can, I'm telling you about Polish process now, so maybe not interesting for everybody, but when I have order for payment, it means that the court reads the papers, I think you're right, and it gives an order for payment, doesn't ask the other party, sends it to the other party and says, if you are not okay with that, just final objection. You can write, I don't agree. You can write many arguments. You can write what you want. And then we switch to normal procedure. And these procedures take longer. Usually it's after the order of payment is objected. It takes about a year when we have to do with evidence of witnesses and so on. Normal court case. A year to year and a half. This is the law. But I have maybe 15% of my cases go to this regular proceeding. the 80, 85 are solved within this shorter proceeding, which should be even as quick as 2 weeks, up to maybe the longest order of payments I was waiting for, maybe some of 6 months or something like that. If it's beyond that, I'm getting annoyed and I'm writing a report.
And the second question, no,
Yes,
no
of course.
5 questions. The second one, do you try to instigate to mediation? Let's say, I don't know, rather than wait for those 15% of the cases, rather than wait a year and a half to pay 80% of the total value, or you don't do that for your customers?
I did. I did that a lot. It's very time consuming because usually the debtors come for mediation when they see they don't have any arguments. So when I go to court and they say, let's mediate, and I was calling them for mediation 3 times, and we were calling them in amicable phase and so on. And they are suddenly now really mediative, and they're very amicable at the point where the gun is held to their head. So I was doing that, and regular mediation usually takes about 2 months. That's what the court gives me for the process. They establish a mediator. We go there. Usually you can do it online. Sometimes some courts do not accept these online settlements. We have to go and make a wet signature. And then there's like maybe 2-3 weeks when the court gets a settlement from a mediator, and they just apply the clause on the settlement. It's just as good as verdict. So I used to do that, but now I just see sometimes in the very like surefire cases, I say that the debtor is trying to win some more time and maybe some more time usually, and and then I had these like after 10 mediations, when the 8th mediation was not paid in the 2nd installment, it just doesn't make that much sense to me anymore. But when they just threaten me with an objection, so I know I will end up in this 1 year procedure, I would rather do that. I would rather do the mediation, yes. But if they say we can mediate, I say, if you wait 2 weeks, please call me on vacation, and his time for objection lapsed, I say no mediation anymore, because I trick them into not filing an objection. Sometimes I'm devious like that.
Thanks a lot. Thank you.
Yeah, okay. Exciting 5 questions. Any more questions? Some more questions, please.
So imagine you don't have any late payment clause in the contract. Contract is simply silent. Can you apply the EU regulation in this case?
Yes, but you have to have any. The contract has to be under some law, because we would need to know which of these rates apply from which country. But as we spoke here about these regulations, there are also regulations in the EU that says if you haven't chosen law, if you haven't chosen jurisdiction, that is what we will choose for you, because we want the surety of the law. So if you haven't chosen the law, no clause about that. The law of the country, that's usually the seller's country, the service provider's country, not the buyer's, not the one who pays paying the money, the one who's providing something specific for the contract. That'll be the law. It's called the Rome I regulation. If you would not specify court, it would say that you can always sue someone in his house. You can always go to country of his residence, of his seat, and go for this court. It's always legal. So in the extreme case where we have nothing in a contract, let's assume it was this case without these 2 clauses, we would have German law and Polish jurisdiction, and the Polish court would have to apply German law, which is problematic and takes a longer time, but it's possible. I've done these cases. I try to avoid that, so better to structure your T&C in a way that it allows you to at least choose or specify the law that you want, and let it be the law of the country where the court is. I tell you that because the judges, as you said, they just love to dismiss, well, not dismiss this case, but they just put them on the shelf and they apply to Ministry of Foreign Affairs to have a quotation on Portuguese law, and they will wait 2 years easily, and they don't have to do anything with the case. So I don't like these cases.
I'm afraid it's time.
We're done? Thank you. You were great. You're great. You can keep your bowl teams and your pipe cleaners. And if you want more pipe, I don't have much left, but you can apply. I think Mark has them in abundance.